All right, good morning, everyone. Let's get started. Court's going to go ahead and ask everybody to please remain on mute until such time as your case is called. Once your case is called, please unmute yourself and identify yourself. But for now, please, everyone, if everybody could remain on mute. I will take quick announcements first. Any attorney here with a quick announcement, please give me a reaction button by raising your hand, letting me know that you're ready and your clients are present. This is the civil docket for Monday, January the 31st. Any attorney with a quick announcement, I'll take that one. All right, Ms. De La Fe Pettis, what do you have?
Hi, good morning, Judge.
Good morning.
I'm here on a case this morning with Darlene Vale, and we are going to be submitting a Rule 11 agreement to pass the case because we just got retained on this case.
All right, that's F54 73-21-8 in the matter of the marriage of Armelo Mancia and Maria Arellano, passed by Rule 11.
Yes, Judge.
Perfect. Thank you, Ms. Bettis.
That's all I have. May I be excused?
You're excused.
Okay, thank you so much.
Have a good day.
Bye-bye. You too.
Bye-bye. Mr. Hernandez.
Morning, Judge. How you doing?
Good morning.
I have two default judgments under Lax Valley Stores, Judge.
All right, let's go ahead and start with number 6, CL 204605H, Lax Valley Stores LTD versus Jose Guadalupe. Is it Arevalo?
Arevalo, Judge.
Arevalo. Is Mr. Arevalo present? Jose Guadalupe Arevalo? If you're on mute, please unmute yourself. Jose Guadalupe Arevalo. Jose Guadalupe Arevalo. Court's going to take judicial notice of all documents in the court's file, including the filing of this action on December 16th, 2020. Citation was issued on December 21st, 2020. Defendant was served on November the 1st, 2021. It was returned to the clerk on November the 8th, 2021. To date, there's been no answer on file. The name was called out 3 times. There being no response, you may proceed with your default.
Sure, Judge. Since you've taken judicial notice of the entire file, as part of the record, you will have a damages affidavit from a representative of Lax Valley Stores. You do have an attorney fees affidavit from my office, Judge. The certificate of last known address is on file, and the service member's affidavit is also on file, Judge. There being no answer in this case is ripe for default judgment. Lax Valley Stores is asking for a final default judgment against the defendant in the total amount, Judge, of $9,288.67, Judge. There should be a proposed order in the judge's queue ready for signature.
Court will go ahead and grant default in the total amount of $9,288.67. That relief is granted.
Thank you, Judge.
Next one you have is CL 212171H, Lax Valley Stores versus Aurelio Munoz. Aurelio Munoz. Is Aurelio Munoz present? If you're on mute, please unmute yourself. Aurelio Munoz. Court's going to take judicial notice of all documents in the court's file, including the filing of this action on June the 15th, 2021. Citation was issued June 16th, 2021. Citation was served on the defendant November the 11th, 2021. It was returned to the clerk on November the 12th, 2021. To date, there's been no answer on file. Name of Aurelio Munoz was called out 3 times. There being no response, you may proceed.
Sure, Judge. As part of the record, you do have our damages affidavit from Lax Valley Stores. You have the attorney fees affidavit from my office, Judge. You have the certificate of last known address and service members affidavit, Judge. There being no answer, this case is ripe for default judgment against the defendant in this case, Judge. At this time, Lax Valley Stores is asking for a final default judgment against the defendant, Aurelio Munoz, Judge. And there is also a proposed judgment in the court's queue ready for signature.
What is the total amount that you're seeking in judgment?
This one, Judge, I didn't put the total, but I'll let you know the logistics on it. The actual damages in this case, Judge, are $2,852.66, Judge. Prejudgment interest in the amount of $385.97, Judge. Reasonable attorney fees in the amount of $1,500. Court costs in this case, Judge. And we're asking for post-judgment interest of 18.00% based on the contract that was signed by the defendant in this case, Judge.
That relief is granted.
Thank you, Judge.
I do have the order. All right. Mr. Hernandez, anything else?
That is it, Judge. Can I be excused?
You're excused. Thank you so much.
Thank you, Judge. Be safe.
Have a good day.
You too.
All right. Mr. Morales, what do you have?
Good. Yes, Judge. Good morning.
Good morning.
Judge, I'm here on F5201-218.
Right. In the interest of Natalie Zapata, a child.
That's correct, Judge.
Right. I have
And
Burkett present?
I'm here. Yes, I'm here, Your Honor,
right.
representing Ruby Reyes.
Ruby Reyes. And who do you represent, Mr. Morales?
Agustin Zapata, Judge.
I'm sorry?
Agustin Zapata.
Agustin Zapata, great. All right, what do we have?
Judge, I believe counsel, Ms. Burkett was going to withdraw from the case, Judge, I believe.
Your Honor, that's correct. But after the hearing this morning, I believe the hearing that Mr. Morales filed is just for a guardian ad litem.
That's correct.
I also set my motion for withdrawal because I'm up here in Bexar County and y'all are down in Hidalgo County. The case has recently been transferred and I'm not sure if I should send, in our county, we don't file proposed orders. So I don't know how you want me to get those proposed orders on my withdrawal after our hearing this morning to you.
Okay, so this case was originally in Bexar County, you filed it, and then it got transferred down to Hidalgo? Is that, am I hearing correct?
There were some procedures done in Bexar County, yes, Your Honor. And then the child's primary residence became down there in Hidalgo County. And at that point, it was transferred.
Okay. And Mr. Morales, you're the one that's requesting an ad litem for the child, is that correct?
That's correct, Judge.
All right. And Ms. Burkett, you're asking that I guess, entertain that motion before your withdrawal or after?
Yes, Your Honor. Yes, Your Honor.
Before your withdrawal?
Yes.
Okay. And do you have any objection to an appointment of a ad litem for the child?
I don't have an objection specifically, except Your Honor, that I would ask that under 107.021, that in determining whether to appoint the guardian ad litem, that you give due consideration to the ability of the parties to pay reasonable fees to appoint such a person. My client is in financial distress right now. She does have a job. She's not receiving child support regularly to include the arrearages, which are significant. She has childcare expenses and normal expenses, basic necessities for her and her children.
Okay, thank you so much. Mr. Morales, are you making the request and on what basis?
Judge, we're requesting this because we believe that the child is, my client believes that the child is not being taken care of, Judge. There's been some situations in the past that we had brought up in the prior courts, Judge, and an attorney had been appointed in San Antonio. However, that attorney, I believe, was ill and had been in the hospital, so was never able to fulfill her role, her duties, Judge. And so we're just asking for one to be appointed down here. There was one that had already been appointed up there, and Ms. Burkett was in agreement when we were up there in San Antonio, Judge. So we just asked for one to be appointed down here.
Okay. The court will go ahead and grant that request, Mr. Morales. Can you submit an order appointing, and the court will go ahead and I guess at this point, given the nature of the financial stability of Ms. Reyes, the court will need to reach out to maybe a couple of ad litems who might want to do this at a reduced rate. And that's going to take me some time. So if you can submit an order, I can reach out to a few lawyers and see if they'd be willing to maybe do some pro bono / reduced rate kind of work and maybe put in some hours. If you can just submit an order, I'll try my very best to try to reduce the rate as much as I can.
We'll do that, Judge.
All right. Now I guess I have to take up the issue of Ms. Burkett, your withdrawal. If you can, I'll go ahead and grant your request, obviously being from Bexar County, and your request for withdrawal. Is Ruby Reyes present here today?
Yes, I am, Your Honor.
Okay, Ruby, you understand that Ms. Burkett is requesting to be withdrawn from your case?
Yes, I do, Your Honor.
And do you have any objection to her withdrawing?
No, I don't.
Okay. And are you going to be seeking to retain local counsel here in Hidalgo County?
Yes, Your Honor, I will.
Okay, perfect. You may have heard that I'm going to try my very best to try to find an ad litem that will work at a reduced rate. We'll make a few phone calls today. The court's going to go ahead and grant Mr. Morales' request for that, and I'll go ahead and grant Ms. Burkett's withdrawal at this time. Ms. Ms. Burkett, if you could just file a motion with an order if you haven't already seeking withdrawal. There's one already? Okay, the court will go ahead and sign off on that. All right.
Okay, thank you, Your Honor. I'll double check that. I know my motion is filed, but I don't know that I have an order setting, but I have not filed the proposed order on my withdrawal. I do not believe.
If
So
you
is
can
that-
go ahead, yeah, if you can go
Okay.
ahead and do that, I'll go ahead and sign off on that.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Judge. May I be excused?
Thank you. Yes, Ms. Reyes, you are also excused. Whenever you have, if you have, or whenever you have a new counsel, please make sure that you notify that counsel of Mr. Morales, and that way they can start communicating with each other, okay?
Yes, Your Honor. Thank you so
All right,
much.
and also, Ms. Reyes, we have your email. We're going to be forwarding that email to the court's appointed ad litem. So if you get an email from that ad litem, please reach out to that person, okay?
Yes, Your Honor. Thank you so much.
You're welcome. Have a good day.
Thank you, Your Honor.
Thank you. Mr. McAllen, what do you have?
Good morning, Judge. I have CL 21-3222H, Elidema Garza versus State Farm, Your Honor. This is a case that was in appraisal. The appraisers, or it finalized the appraisal process. So I'm trying to see if I can discuss post-appraisal settlement of this claim with opposing counsel. If not, I may have to amend my petition to add the post-appraisal fees that are allowed. And so I'm just asking for a little time to see, maybe 60, 90 days to see if I can work that out with opposing counsel. I think he's here. I thought I saw.
Good morning, Your Honor. Actually, this is
Okay.
Andrea Bella for State Farm. We actually set this case for a status conference hearing because the appraisal award has been paid. The plaintiff has made a post-appraisal demand and State Farm has responded to that demand. It's State Farm's position that there is nothing further owed and that this case should be resolved at this point.
Okay, so I guess there's a disparity in what I'm hearing. Mr. McAllen wants more time.
Yeah, a lot of people tend to tell me no in the beginning, but I'm quite I don't give up, Your Honor. So I've had I think if you give me a little time, if not, I can amend my petition to include what we need to and move forward in that. But I have faith in my persuasiveness in that area. I've settled most of my stuff with State Farm post appraisal, so I just was asking for a little time on it.
All right, let me give you March the 30th, Mr. McAllen,
Thank you, Your Honor.
at 9:30, okay?
Thank you, Your Honor. That's all I have before this honorable court, Your Honor. May I be excused?
All right, yes, you may. Thank you.
Thank you, Your Honor. Have a good day.
That's all I have as well, Your Honor. May I be excused?
Your excuse, thank you.
Thank you.
All right, I do have a representative. Let me see, where is, oh, Mr. Sanchez is in another court. I wanted to take care of his case. Mr. Michael Guerra, what do you have?
Good morning, Your Honor. I'm here on cause number CL 20-3358H, Andrea Corona versus Brianna Garza and Geico. I know that Mr. Roger Garcia is also here, and it's his motion to be heard.
All right, and is Mr. Gibson on the other side or someone standing in for him?
Mr. Gibson is on the other side. I don't know if anyone is going to be standing in for him, Your Honor.
All right, do we have Mr.
Good morning. Good morning, Judge. Rogelio Garcia representing Geico County Mutual Insurance Company. And Mr. Guerra is correct. This is my motion to compel discovery, written discovery against plaintiff. And I've tried reaching Mr. Gibson numerous times, have not had any success.
All right, give me 1 second, Mr. Garcia. Maybe we can have a little, maybe we're more persuasive than you. Although you all have the pocketbook, so I don't know why I would be more persuasive, but we'll figure that one out here real quick. Give me a couple minutes. We'll try to make
Yes.
contact with Mr. Gibson.
Yes, sir.
Thank you.
Thank you. Your Honor.
All right.
We'll stand by.
Thank you. Mr. De Leon, what do you have?
Good morning, Judge.
Good morning. What do you have?
Judge, I have CL 21-3958-H, State Farm versus Angelo and Viviani de Chavez.
All right.
Michael De Leon on behalf of the plaintiff. I believe opposing counsel is present as well.
Here, Your Honor.
All right. What do we have this morning?
Judge, we have a motion to appoint an umpire in this case. However, it's come to my knowledge that an umpire has already been selected by the court.
This is one of those cases where I think Eddie kind of filled me in on Friday when we were going over our docket for today and let me know that he had sent something to my queue. My understanding was that there was no objection to an umpire being appointed. Is that correct? That you all are in agreement with an umpire being appointed?
That's right, Your Honor. What happened was Mr. De Leon's office filed the application. I filed a response. I requested a hearing. The court appointed an umpire a few weeks ago. And it was my understanding the court wanted to keep this hearing on the docket just to discuss your appointment since we didn't have a hearing before.
Gotcha.
I have no objection to having an umpire. I think we need an umpire. As I said in my response, I think the issue is whether the umpire is qualified. I think the umpire is actually on the line. The court appointed John Rigney.
Right. So I kind of been going over these type of cases recently, and I know that there's quite a number of qualifications that are required for an umpire. I know I don't want to speak for Mr. Rigney, but I do know in speaking with him that he meets all the requirements: engineer, contractor, lawyer, experience in, so you might want to ask him some questions about that if that's something that you care to do.
Well, if I might, Your Honor, I'll just point out, I think he satisfies most of the requirements. And I'll note for the record, I didn't file any written objections before today's hearing.
Okay.
I just thought this was an opportunity to discuss this with the court, perhaps clarify what this policy requires. The policy does require any of those professions to be the umpire. Doesn't have to be all of them. I'm assuming Mr. Rigney and the court believes that he's a contractor. It's my understanding that he was a contractor and is currently a lawyer. But, assuming he satisfies the contractor requirement, one of the requirements is that he has experience and training in construction, repair, and estimating of the type of property damage in dispute. I represent State Farm on a number of matters, and I've seen Mr. Rigney's work product on some of those matters. I don't believe he satisfies the policy's requirement for estimating property damage. And I say that because I've seen his awards and I've seen issues arise because of his awards. The policy requires an itemized estimate, which basically, means you go through every single item that's in dispute and you set the amount of the loss, the amount of damage to each item on a replacement cost, actual cash value basis, which means, setting the amount of depreciation, et cetera. Most appraisers, adjusters, they have some sort of training in using a software called Xactimate or another type of software. I don't know if Mr. Rigney has that experience and training. I've just seen his work product and I thought it was lacking. And in terms of being an attorney, yes, in many insurance policies, that might be some sort of benefit. In this policy, it's very strict about what the scope of the umpire's authority is. He's only qualified, he only has authority to determine the amount of the loss. The policy accepts from that authority. It specifically says you can't decide other questions of fact, other questions of law, questions of contractual issues, questions of coverage. And I think when you appoint an attorney, and I'm sure Mr. Rigney is not biased, but I think his training as an attorney can get into the appraisal. I mean, it's hard not to. He's a practicing lawyer. He might try to say, I think the contract requires this because he's a lawyer. And that's why, I as a threshold matter, I always suggest, the court should appoint a qualified adjuster, contractor, somebody who that's what they do for a living and who will be able to write the estimate. And I'll just say that in the matter that I handled that I was referring to earlier about Mr. Rigney, ultimately, State Farm did not pay the appraisal award. There were lots of issues with it, and so they didn't pay it. And so, I mean, we can go down that road now. I'm not saying that's going to happen now. Maybe Mr. Rigney will work with the other appraisers to try and come up with something that is itemized and satisfies all the policy's requirements. It just creates issues. And in my opinion, it's not the best scenario, but I just wanted to bring that to the court's attention.
All right, Mr. De Leon, anything to add on this issue?
Your Honor, I have no objection to Mr. Rigney being appointed as the umpire in this case. I do know, I've heard through the grapevine that he's the contractor. He's built commercial buildings, residential properties. I have no objection, and nowhere in the policy does it say that the umpire has to be able to use Xactimate software. Okay, that I haven't seen that yet, and so Again, I have no objection to Mr. Rigney being appointed as the umpire in this case, Your Honor. I think he's qualified. I don't think he was on the list that I submitted to the court. Nevertheless, I have no objection.
All right. Let me ask Mr. Rigney. Mr. Rigney, is this something that you would like to handle? I know that the court knows of your experience as both as an engineer, as a contractor, as a lawyer, but obviously I made that decision believing that both parties were in agreement with the need, which I think everybody is in agreement that there is a need.
Yes.
Is this a case you would be interested in handling, Mr. Rigney?
Sure, Judge, not a problem. Just for the court's record, yes, I did graduate in 1996 from University of Texas as a mechanical and manufacturing engineer, and I have a minor in electrical engineering. I've been doing construction since 1987, so I've been a general contractor for over 35 years, I think, if my math is right. And currently I am a practicing attorney, but I'm also doing, multi-million-dollar projects on an annual basis. So probably 80% of my income is derived as a general contractor versus as a practicing lawyer. So I hope that satisfies Mr. Adler's position as far as, it should be a contractor. And as far as projects goes, I've done everything from, $100 patch jobs to $15 million schools, houses. Currently, I have several big remodels going on. And so I do re-roofing, I do remodeling projects. I do everything that is required of this position, Judge. And I absolutely make my rulings based on my construction experience and based on what I believe needs to be done to the projects. I'm not swayed one way or the other. And I've never heard of any award that was not given because it wasn't itemized in Xactimate. But if Mr. Adler is willing to send that file to me and represents to this court that the only reason they haven't paid it is because they want it on Xactimate, I will put it on Xactimate and send it back to him so they could pay it.
All right. Look, I guess at the end of the day, the court needs to feel comfortable in appointing somebody who can do the job, and I think Mr. Rigney can definitely do the job. So the court's going to go ahead and keep Mr. Rigney as the umpire in this case. And I think at that point, that's really all I need to do is I just need to, I guess, keep the order in place. I think that we already had an order, and I think I'll just keep it and let you all do your work and continue from here. And the three of you will continue working and communicating with each other. And if you need help from the court, well, that's what we're here for.
All right.
Thank you, Your Honor.
All right. Okay. Anything else, Mr. De Leon?
I have nothing further, Judge.
Yes, Mr. Adler, anything else?
No, Your Honor, may I be excused?
Yes, Mr. Rigney, do you have something else with the court?
I do, Your Honor. The reason I was on, I wasn't even aware about this case, but I have a PI case coming up, Judge.
Okay, and that is CL 1921-16H, Tiffany Pettis versus Sergio Gonzalez, Chapa de Leon Transportation Group, LLC.
Yes, Your Honor.
Robert Pettis for the plaintiff, Your Honor.
Good morning, Mr. Pettis.
Good morning, Your Honor.
I
Good
know
morning,
last time
Judge,
we were-
and Marco Hilpas for the defendants on this case.
Okay, Marco.
I don't know if Tiffany's here. Tiffany, are you here?
I know at some point, Mr. Pettis, we had some difficulty trying to locate Tiffany. Is that correct?
We were able to locate her, and John has spoken with her and I think approved the settlement. And she knew about the hearing date. I guess John told her, I told her as well. So I do not know why she's not in attendance.
I have somebody on a phone. Maybe that
That's what I was
her.
hoping was her.
Tiffany Pettis, if you're on mute, please unmute yourself. Tiffany Pettis, you may be on mute. If you're the individual on the phone or the person on the phone, can you identify yourself just by name, please? You can unmute yourself, whoever is logged on by the phone. Mr. Rigney, do you have any communication with this?
That's not, the number I had, Judge, for them was ending 5235. So that's not them, Judge.
Okay.
I was able to finally it took forever, but I was able to finally contact the mother and the child. and interview the child. There are some issues that I didn't feel comfortable with the child. But after reviewing the file further and looking at the dates of treatment and all, the child made an outcry that she still wanted treatment, but it's been 4 years. And in the beginning, she didn't get treatment for a very long time. So I believe that there's problems with the case where ultimately I made the decision that I believe it's the amount they're offering is fair and it's in the child's best interest, Judge.
Okay, I obviously think that Mr. Hilpas, you're probably of the opinion that we need to have her on and have her testify and put her under oath and ask her a series of questions versus,
Judge, that's generally how I've gone about it, just to make sure that everything is documented in the record, that she understands that of the settlement that we reached on behalf of the minor, a portion of that is going to be deposited into the registry of the court. But if Your Honor feels comfortable doing it another way, I'm okay with that.
Okay, Mr. Pettis?
Yeah, I'm
Judge,
totally
I have her
fine
on the
with that,
phone, Judge,
and
1 second.
It's
It looks like maybe Mr. Rigney was able to get her on the phone.
Yeah, it looks like he's talking to her, Judge.
No, es ahorita, lo tengo en audiencia ya. I have her on the phone, Judge.
Okay,
Hear her?
yes, I can hear her.
Well, let's just, Judge, because this case has been extremely difficult.
Yeah, no, let's finish this and let's figure it out. Mr. Rigney, does she need a translator?
Yes, usted no habla inglés, ¿verdad, ma'am?
No.
Yes, she needs a translator, Judge.
Okay, Mr. Pettis, are you comfortable going forward like this?
I am.
Okay, Carlos, if you can translate, even though I know Mr. Rigney can probably translate, but since he's the ad litem, I'll have our bailiff translate. Okay, Carlos and John, if we can just make sure that we can hear each other through, or Miss Pettis, okay?
Yes. Sí escucha la corte, ¿verdad, Ms. Pérez?
Sí, sí, la estoy escuchando.
Perfect. Okay, Ms. Pettis, if you could please, where you are, raise your right hand.
Ms. Pérez, sí, por favor, ahí donde esté, si puede levantar su mano derecha, por favor.
And I will ask you, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Y le voy a preguntar, ¿jura que el testimonio que habrá esta mañana será la verdad y solamente la verdad?
Correcto.
Correct.
All right. Mr. Hilpas, Mr. Perez, who would like to proceed first with questioning of Ms. Pettis, Tiffany Pettis?
I have a few questions, Judge, and I'll be very quick.
Go ahead.
Good morning, Ms. Pettis. Can you please state your full name for the record?
Buenos días, señor Pérez. ¿Puede decir su nombre completo en voz alta, por favor?
Tiffany Samantha Lee Perez.
And Ms. Pettis, where,
I'm sorry, I didn't get it. ¿Puede repetirlo, por favor, un poco más despacio?
Tiffany Samantha Lee Perez.
Tiffany Samantha Lee Perez.
and Ms. Pettis, we're here this morning for a lawsuit that you filed on behalf of your minor daughter. Is that correct?
Y estamos aquí, Ms. Pérez, hoy presentes en esta audiencia por una demanda que usted archivó por parte de su hija, ¿correcto? ¿Es correcto?
John, you're on mute.
Sorry about that, Judge. Dígalo otra vez, Samantha.
Sí, correcto.
Yes, correct.
And this was for an accident that happened on April 27th, 2017 in Alice, Texas, correct?
Y esto fue por un accidente que ocurrió el 27 de abril 2017 en Alice, Texas, ¿correcto?
Sí, correcto.
Yes, correct.
And at mediation, we were able to reach an agreement in the amount of $20,000 for your daughter. Is that correct?
Y cuando fuimos a mediación, llegamos a un acuerdo de $20,000 para su hija, ¿correcto?
Correcto.
Correct.
And of that amount, $10,207.22 is going to be deposited into the registry of the court. You understand that, Ms. Pettis?
Y entiende que la cantidad de $10,207.22 se va a depositar con una cuenta a la corte. ¿Es correcto?
O sea, no le van a dar los 20,000.
They were gonna give her the 20,000.
That's correct. So the settlement is $20,000, but there's a portion that's going to be deposited into the registry of the court. Do you understand that?
Sí, el acuerdo es $20,000, pero hay una porción que se va a depositar con una cuenta de la corte. ¿Entiende?
Sí, ¿y eso se lo van a dar también a la niña o cómo está eso?
And that they're gonna give it also to the little girl, or how does that work?
Yes. So when your daughter turns 18, she'll be able to request access to those funds. Do you understand that, Ms. Pettis?
Sí, cuando su hija obtenga la edad de 18 años, ella puede pedir a tener acceso a esos fondos. ¿Entiende, Ms. Pérez?
A los 20,000, ¿verdad?
For the 20,000, right?
Robert, I'll have you kind of go into details in a little bit with that in the settlement with her. But just for the record, Ms. Pettis, you do understand that ultimately at mediation, there was a settlement reached for the claims that you brought on behalf of your daughter. Is that correct?
Ms. Pérez, para el acta, sí entiende que en el mediación, cuando fueron, llegaron a un acuerdo de $20,000 por parte de su hija. ¿Es correcto?
Sí, correcto.
Yes, correct.
Okay, and whenever your daughter turns 18, she can't come back and file a lawsuit for the same injuries that allegedly arose from this accident. You understand that?
Y su hija, cuando obtenga la edad de 18 años, no puede regresar de nuevo a archivar otra demanda por parte de este accidente. ¿Entiende?
Sí, entiendo.
Yes, I understand.
And instead of reaching a settlement, you understand that you have a right to go to a jury trial, and that a jury might award you more money, less money, or no money. You understand that?
Y en vez de llegar a un acuerdo, entiende que usted puede ir ante un jurado y un jurado le puede dar más dinero, menos dinero o nada de dinero. ¿Sí entiende?
Sí, entiendo.
Yes, I understand.
And no one has pressured you or forced you to enter into this agreement?
¿Y nadie la ha forzado o amenazado para que llegara usted a este acuerdo?
No.
No.
And you understand that the court has appointed Mr. John Rigney as an attorney ad litem in this case. You understand that?
¿Y entiende que la corte ha asignado al abogado John Rigney como abogado ad litem en este caso?
Sí.
Yes.
And you've had a chance to speak with him, as well as he's had a chance to speak with your daughter?
¿Y usted ha tenido la oportunidad de visitar con él, lo mismo como él ha tenido la oportunidad de visitar con su hija?
Sí.
Yes.
And at this time, you're asking the court to approve the settlement, and you're in favor of it. Is that correct?
Y en ese momento usted le está pidiendo a la corte que apruebe este acuerdo y usted está de acuerdo.
Sí.
Yes.
Judge, I have no further questions. I'll go ahead and pass the witness.
All right, Mr. Pettis, do you have any questions?
I have no questions, Your Honor.
All right, Mr. Rigney, do you have any questions?
Yes, Judge. Ms. Pérez,
Mande.
sí,
Yes.
bien, ¿verdad?
Okay.
Judge, I apologize. Ms. Perez, you understood properly how the 20,000 is being distributed?
Ms. Pérez, ¿entendió apropiadamente cómo se iba a distribuir los $20,000?
Sí, de que los iban a meter al banco y luego cuando ya la niña tenga 18 años le van a dar los 20,000, ¿verdad?
Yes, when it's going to be deposited to the court, and then when she obtains the age of 18, she's going to be able to get the 20,000, correct?
That's not correct.
Eso no es correcto.
Judge, because she's Mr. Perez's client, can Mr. Perez explain the breakdown to her?
I'll do this quickly.
Yes, go ahead, Mr. Pettis.
Mrs. Pettis, when you came into my office, you signed what's a disbursement. I don't know, it's been so long, you may not recall that, correct?
Ms. Pérez, cuando usted vino a mi oficina del abogado Pérez, usted firmó el documento para distribuir los fondos. No sé si recuerdo porque ya hace mucho tiempo. ¿Es correcto?
Sí, correcto.
It's correct.
In that disbursement, it showed that of that $20,000, $10,207.22 is going into the registry of the court for Miss, for your daughter when she turns 18. Do you understand that?
Y en ese documento indica que se iba a instruir $10,207.22 que se iba a depositar con la cuenta de la corte para uso de su hija cuando tenga la edad de 18 años. ¿Entiende?
Sí, sí, entiendo.
Yes, I understand.
The rest is going to medical bills and attorney's fees and expenses.
Lo demás se va a ir a biles de médicos y gastos de otros gastos y costos de abogado. ¿Entiende?
Sí, sí, entiendo.
Yes, I understand.
I'll pass witness, Judge.
Okay,
Right,
so Ms.
Mr.
Perez, just real clear, you know that when your daughter turns 18, there's only gonna be $10,000 and some change, or not 20,000, correct?
Espera, so entiende que cuando su hija obtenga la edad de 18 años va a haber 10,000 y fracción de la cantidad, no 20,000. ¿Sí entiende?
Sí, sí, entiendo.
Yes, I understand.
And Ms. Perez, do you think that settling this case right now is in the best interest of your child?
Y espera, siente que aceptando este acuerdo hoy es en el mejor interés de su hija.
La verdad no, porque la niña tiene bastante trauma y tiene bastante como ella tiene bastantes pesadillas. Ella no se puede subir a la troca, como le comentó mi hija al señor que habló, no sé quién sería con el que habló ella, pero ella sí quiere ir a psicología y a terapias para quitar ese trauma y ese miedo que tiene ella.
Well, really no. My daughter's still traumatized. She still suffers from nightmares and she really can't even get on the truck anymore. And she wants to go to get some psychological help for the trauma.
Ms. Perez, we talked about that. We spoke about that, but your daughter skipped treatment for so many years. You need to discuss that with your attorney, and I advise you to do that. Did you do that?
Sí, pero la attorney mía no me contesta. Ella no me contesta. No sé si por la razón de que le estoy pidiendo todo el documento, porque yo también tengo el derecho de recibir todo el documento que yo firmé. Y ya tengo desde que firmé, que le dije que el lunes iba a ir y hasta ahorita ella no me ha entregado los papeles. He estado marcando, aquí tengo las llamadas donde le marco. Y
Permítame, ma'am. Tengo que traducir.
No me contestan.
Permítame, tengo que traducir, ma'am.
¿Cómo quiere que le haga si
Espérese,
voy a la
espérame
oficina y no
tantito,
me
Miss
abren
Pérez.
la puerta? No me contestan que porque por el COVID no pueden abrir.
Sí, Ms. Perez,
Pérez.
tienen que traducir todo esto lo que dijo. Go ahead.
No se vayan en oraciones largas, ma'am. Tengo que traducir todo por completo. No, because my attorney would not return my phone call. She would not answer me. And I have a right to get all the paperwork which I had signed. And when I've gone over there, they would not even open the door, saying because of COVID. Excuse me. Hey. Okay, ¿qué más había dicho, ma'am?
Sí, pues yo les he estado hablando, le hablé del teléfono ese, le estaba hablando el teléfono de mi esposo, pero como se saben los dos teléfonos, el mío y el de mi esposo.
And yes, I've been calling the numbers there and they're not answering since they know both our numbers, mine and my husband's.
So, Judge,
Por eso pienso yo que no me contestan, porque yo ya les he estado diciendo que me entreguen el papeleo.
That's why I feel that they're not answering.
Judge, these are some of the issues I spoke about. And I don't know if we should maybe go to a private conference to discuss this since there is a minor involved.
Right.
We should go into a private. Un segundo, Miss Pérez, un segundo. Miss Pérez, un segundo, espérese, por favor. No, espérese tantito.
Sí.
Sorry, Judge.
I agree. Let me
We should discuss this in private, Judge.
Yeah, let me put us all in a breakout room real quick so we can discuss this. Give me 1 second. I'm gonna put if you can just put your Pettis on mute.
Sure.
So
And then
ustedes se
let's go
conectan.
Mr.
No cuelguen.
Pettis and Mr. Gilpas. There's just, I think that's it. All right, please accept the invitation. I'll meet you guys there. Mr. Rigney, whenever you get a chance, if you can hit accept into the breakout room, I'll join you all there. Okay, we are back, and everybody who was in the breakout room is on mute. So just FYI, in case you all are not aware that when you return back, you were placed on mute. Court is going to recall CL 19-2116H, Tiffany Perez versus Sergio Gonzalez, Chapa de Leon Transportation Group LLC. I know that when we left and went into a virtual chambers, we were discussing Mr. Rigney talking to Ms. Perez, and Ms. Perez speaking about the fact that she was concerned about the settlement. However, I know, Mr. Gilpas, that one of her concerns was that I guess that her child was suffering from additional situations, I guess we could probably call them that she was having dreams, nightmares, fears, anxieties about getting into a vehicle, and then that she was also having some issues with wetting herself as a result of that fear. My understanding in visiting with you, Mr. Gilpas, is that you all took a deposition. Is that correct?
That's correct, Judge.
And none of this was brought up during the deposition?
Judge, we went pretty good in detail about the events leading up to the accident, the treatments, and to my recollection, it's been a while since I've looked at the transcript, but none of those issues that have been brought forth to the court this morning were discussed either during the deposition or during any of the discovery requests that were exchanged or at mediation. So for all intents and purposes, that information is new to me, Judge.
All right. And Mr. Pettis, you've obviously, that she's your client and you've had some communication with her throughout this process. And at that deposition, you were there. Would you agree that this has never been brought up or hadn't been brought up until now?
I don't recall that being brought up at all. And it wasn't brought up during mediation. They were quite happy with the result at the mediation. I think it was, who mediated it? Was it I think it was Gil.
I think it was Gil. Yeah, I think that's right.
Okay. I kind of suspect that she, from what I've gathered, she kept talking about, well, will the child be able to get the $20,000 when she turns 18? This may be some confusion on her end that the settlement was for 20,000, but maybe is confused about the expenses that come with a case like this. But all that was explained to her, Mr. Pettis, correct?
Yeah, and she signed, and that's what the question I asked her at the very beginning is, did she recall signing that disbursement? She signed her disbursement as well as Jasmine's disbursement. And what that is a document that shows exactly how much the settlement is, how much goes to attorney's fees, how much goes to medical expenses, and how much goes to general expenses. And she signed off on that.
Now, let me ask Mr. Rigney, in reviewing those disbursements, Mr. Rigney, do you feel that they're reasonable given the settlement?
They're reasonable, Judge. I think it should be approved.
All right. And you're asking that this be approved. Is that correct?
Correct, Your Honor.
All right. The court's of the opinion that this settlement will be approved. My understanding is that there has been an agreement with respect to your ad litem fees. Is that correct, Mr. Rigney?
Yes, Judge.
All right. Go ahead and include that into the final settlement documents and final judgment, and the court will go ahead and approve that.
Very good, Judge. And we've already drafted the final judgment. I'll go ahead and incorporate Mr. Rigney's fee for his ad litem services, and we'll get it filed with the court.
Okay, sounds good. Thank you so much.
The only thing, Judge, should the court put a deadline on the disbursement of the funds into the registry of court and stuff, just so it doesn't procrastinate?
Yeah. What do you think, Mr. Gilpas? How long would it take for you to get those checks?
In my experience with this insurance this insurance carrier, it usually takes about 2 weeks.
All right, so let me go ahead. We'll set a stickler for 30 days on our end to make sure that it's done within 30 days.
February 4th.
All right, that'll be February 4th. That'll be on our end. We'll just make sure that all that's taken care of.
Thank you, Judge.
Very good, Judge.
Mr. Rigney, will you let her know that the settlement has been approved?
She's been listening, Judge.
Okay, perfect. Thank you so much.
Thank you, Judge.
Thank you. All right, I have a jury trial that is scheduled to begin this afternoon. The attorneys would like to visit with me on the phone. So if I could just have the attorneys who are on Zoom, please be patient. I'm going to put myself on mute so I can handle that phone call and see what information they have for me. Give me 1 second. All right, I know that some of you are maybe on mute and have your camera off. I was able to take care of that matter. I am back. Mr. Salinas, I see you there with your hand raised. What case do you have? You're on mute, sir.
Good morning, Judge. Roy
Good morning.
Gutierrez, Judge, and Robert Salinas, Judge. We have a F 2762-21-8 in the interest of Heaven Diaz.
Right. And who are the parties in this case?
Judge, we represent Daniel Diaz, Judge. He's the non-custodial parent. And Dulce Machain is the custodial parent, Judge. I believe I see her on the system there.
Dulce Machain. All right, Dulce.
Good morning, Judge. Adrian Sanchez, on behalf of the AG's office. This is initially a AG petition that was originally in the master court. It was referred back.
All right. Thank you for joining us, Mr. Sanchez. Dulce, can you hear me?
Yes, sir.
All right. And Dulce, do you happen to have an attorney representing you?
No, sir.
Okay, pro se. And what do we have today, Mr. Gutierrez?
Judge, I believe today, Judge, we're set for a petition to establish the paternity, Judge, and to submit orders, Judge. However, Judge, we filed a countersuit back in August, Judge, of last year. We requested discovery, Judge, and we've asked for mediation. And that's what we're asking for today, Judge, for the court to send us off to mediation so we can agree on something.
Okay, so let me get this straight. This is a hearing to establish the parent-child relationship, meaning Mr. Diaz is the father. He is seeking to be to have a judicial determination that he is in fact the father. And then you filed a counter petition, I'm assuming seeking primary conservatorship?
That's correct, Judge.
Okay. And the Attorney General's office position is we're here because the state's receiving some sort of governmental assistance or has provided governmental assistance of some kind and you have an interest.
Yes, this is actually a Title 4D initially case, Your Honor, in master court. It was referred back.
Okay. Ms. Machain, do you happen to have any input into this?
No, sir.
Okay. Mr. Gutierrez, I'll take, I guess, I'll follow your lead. I'm assuming you're asking for me to, has there already been a judicial determination? No, correct? In the Title IV, in the master court, there wasn't a determination of parentage?
I don't think it was established, Judge. I believe it was transferred over, but it may have. It may have been. I don't know what the OAG has any records of that.
You know, we have, DNA was conducted. We have the results, but we never obtained any type of order. There is no order yet.
Okay, and what are the results of the DNA test show?
It's positive results, Your Honor. We can establish a paternity. That's the first issue.
All right.
Or we can leave that issue pending.
No, let's cross that bridge now. I mean, there's no
Yes, Judge, and we have no objection to paternity, Judge.
Okay, so let's cross that bridge now so that everything else can start and flow from there. Okay. Okay. Who would like to proffer that evidence?
Your Honor, I believe the state has already filed the DNA results in this case, Your Honor. We can offer them into evidence as Exhibit A. I believe they should be in the court's file.
All right, I am seeing them now. I'm seeing them now. State's Exhibit A is admitted. And it does establish that Daniel Diaz is the father. Is that correct, Mr. Sanchez?
Correct, Your Honor.
All right. And that probability is 99.9999%. Okay, so the court will sign off on an order establishing that Daniel Diaz is the biological father of Heaven Diaz. Where does that now put us, Mr. Salinas, now that the court has made that judicial determination? Mr.
Yes,
Gutierrez?
Judge, we're asking that, Judge, there's no temporary orders in place at this point, Judge. We're asking the court to send us off to a mediation to discuss some temporary orders, Judge, or final orders.
Okay. Ms. Machain, do you understand what Mr. Gutierrez is requesting?
No, sir.
Okay, so he's asking that I send you all to a mediator to discuss temporary orders and quite possibly final orders. Now that Mr. Diaz has been determined as being the biological father, with that comes certain rights that he has that he most likely will be seeking to invoke. Those rights could include visitation. They could include fighting for custody. So I'm not sure exactly at this point what they're seeking to do because Mr. Gutierrez has not advised me. But what he is telling me is that he's asking to be going to mediation. Assuming that this is going to be a contested hearing, I would send you to mediation anyway. So that's something that would need to happen. The question is whether you want to appear at that mediation with or without a lawyer. You know, that's totally up to you. And at this point, what I can tell you is that the mediation would probably occur within the next 30 days. So you do have some time, not a lot of time, but some time to seek legal counsel if that's something that you choose to do. Okay.
Okay.
All right. Mr. Sanchez, I guess at this point, the Attorney General's office is remaining silent on everything else until such time as they come back.
Yes, because of the issue that primary conservatorship was being contested, we can't really set up any orders until that issue is resolved. We can submit just the order to establish if the court, it's okay for us to submit that order, we can submit it.
Yes, please. That would be helpful. That way we can clean this file up. Okay, Mr. Gutierrez, do you have a preference as a mediator? Who you'd like to see as a mediator?
Judge, I was thinking of Andrew Almaguer, Judge. I know he's an assistant district attorney and he does a lot of family law mediations, Judge. He's helped me resolve a lot of situations before.
I have no problem with Andy Almaguer. The court will go ahead and place Andy on the order that's been submitted to the court. So Andy Almaguer will be the mediator, Ms. Machin. If you can be on standby and, you know, if he calls you or someone from his office reaches out to you, Andy Almaguer will be the mediator in this case, okay?
Okay.
Okay. Let me set this up for a status date in 45 days. That'll give y'all the next between now and 45 days to try to mediate this case with between you all. Reset for 45 days, which would put us. All right, that'll be March the 9th. It's a little under 45 days, but it's by a week, March 9th, 2022 at 9:30. Any questions from anyone?
No, sir. No, Judge.
All right, Ms. Machin, any questions?
No, sir.
Thank you. Then both of y'all are excused. Mr. Sanchez, I'd like to keep you on the Zoom call because there is another case that I'd like to see about maybe you helping. I know that Ms. Malacara, Adriana, that's number 1, F 2486-21-8 in the matter of the marriage of Adriana Malacara and Jose Vazquez. Mr. Vazquez is on the phone. I know last time we were here, there was an issue with their pro se divorce that I had asked that they reached out to the Attorney General's office. And it's with Eddie this morning. My understanding is that they may have reached out to the Attorney General's office. Can you confirm?
That is correct, Your Honor. We are a party now to believe to the case, so we are ready to proceed.
Awesome. Okay. Mr. Salinas, Mr. Gutierrez, then you all are excused. Ms. Machin, you all are excused. And we'll see you on March the 9th. And we'll move on to the other case, F 2486-21-8.
Thank you, Your Honor. Thank you, Judge.
Thank you. Thank you, guys. Have a good day. In the matter of the marriage of Adriana Malacara and Jose Vazquez. Ms. Malacara, can you hear me?
Yes, sir. Good morning.
Good morning. And Mr. Vazquez, I know you're on the phone. Can you hear me?
Bueno.
Yes, sir. Can you hear me?
¿Me escucha?
Sí.
Yes.
Sí.
Okay. Mr. Sanchez, you all have filed an intervention in this case?
Yes, Your Honor, we did actually file an intervention recently on this case, and we did talk to the parties, I believe, last week regarding the support amounts in this case.
And were you able to come up with those amounts?
Yes, we did discuss it with the parties. We have a recommendation for the court regarding the support amount.
Okay. I know that Ms. Malacara, based on that communication with the Attorney General's office, were you able to modify the final order?
Yes. Well,
Yes?
I turned in everything.
Let me just make sure. I'm going to look at the final order. Mr. Sanchez, did you give them any language as to the child support amounts?
I don't believe they submitted a new one, Your Honor. They still have the original one, which has blanks on the support. I mean, we can read the amounts to the record and then we can provide them language so they can incorporate it into the decree so they can file a new one. Because they do lack, it's blank. I did see the.
Yeah, I'm still seeing it being blank. And as I explained to them, and obviously I sympathize with the financial situation where most people want to try to do this on their own. And we definitely want to help them as best we can. However, I can't, A, give them legal advice, and B, I can't do that kind of work for them. So that's why, you know, honestly, the Attorney General's office coming in onto these cases helps us tremendously. And you all provide a great service to the community and to the public at large by coming on board in these cases. I know that a lot of times the state has an interest in these type of cases and people are just unaware. And so they don't get the Attorney General's office involved when they should be involved because there should be reimbursement to the state. So I want to thank you, number one, Mr. Sanchez, for joining us and getting on board and helping. How do you recommend that we do this, Mr. Sanchez? Do you recommend I'll follow your lead. I want to make sure I have a complete order. I want to make sure that everyone is taken care of and protected. And I want to make sure that the parties don't come back later and that order isn't complete. So I'll follow your lead, whatever you think would be best here.
I mean, what we've done in the past usually is we would recommend the amounts, put them on the record, the same as a divorce. And I'm not sure because we're not actually the petitioner for divorce. We can provide them the language regarding the support amounts, and that's pretty much about it. We can't really help them with the division of property or any of those issues because this is a divorce, but we can provide them with that language.
How about we do this? How about I prove up the divorce and then you send the language to the court and the court will incorporate it by reference into the decree. And I can help in that regard. I can basically leave it up to you to give it to me because I trust that that as an officer of the court, you'll provide me with that language and then I'll incorporate it by reference into the final decree and attach it as like Exhibit A.
We can do that, Your Honor. We can do that.
Perfect. All right, Ms. Malacara, are you prepared and ready to proceed?
Yes, sir.
All right, and Mr. Vazquez, are you prepared and ready to proceed?
Español. Señor Vazquez, ¿está usted listo y preparado para proceder aquí hoy?
Sí.
Yes.
Okay. Can I have both of you please raise your right hand? And Ms. Malacara, can I have you turn on your camera, please?
There you go.
Okay. Can I have you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And same question to you, Mr. Vazquez.
Señor Vazquez, ¿jura que testimonio que va a haber esta mañana va a ser la verdad y solamente la verdad, señor?
Sí.
Yes.
All right. Ms. Malacara, you are the petitioner in this divorce decree, is that correct?
Yes, sir.
All right. And prior to filing this petition for divorce, had you lived in the state of Texas for 6 months?
Yes, sir.
And in the county of Hidalgo for 90 days?
Yes, sir.
During the course of your marriage, were any children born or adopted?
Yes, sir.
And those children are Luis Vazquez and Gael Vazquez, is that correct?
Yes, sir.
All right. Are you expecting any children at this time?
No, sir.
During the course of your marriage with Mr. Vazquez, was any community property acquired?
No, sir.
All right. And has your marriage to Mr. Vazquez become insupportable and you're asking the court to grant you a divorce at this time?
Yes, sir.
All right. Now, with respect to the children, you are asking to be named joint managing conservators. Is that correct?
Yes.
And the children are currently receiving governmental assistance. Is that correct?
Yes, sir.
All right. And you all have reached out to the Attorney General's office and you all have begun the process of opening up a case with them. Is that correct?
Yes, sir.
In fact, they have joined this case and they are now present here today to help and assist in child support. Is that correct?
Yes, sir.
Have they gone over the amount of child support that you will be receiving as the primary custodian of the child, the children?
Sir.
I'm sorry. And are you in agreement with that?
Yes, sir.
And do you feel that that's fair and equitable to your children
Yes, sir.
and to yourself?
Yes, sir.
Okay. Mr. Vazquez, You
Señor
are,
Vázquez,
you are the father to two minor children, the subject of this divorce. Is that correct?
usted es el papá de dos hijos menores en esta demanda, ¿correcto?
Sí.
Yes.
Were you aware that the Attorney General's office was involved in this case to try to determine the amount of child support?
¿Sabía usted que la oficina del Attorney General se había puesto una intervención para determinar manutención de los niños?
Sí.
Yes.
And have you been made aware of the amount that you're going to be paying in child support?
¿Ya le han avisado de la cantidad que iba usted a pagar la manutención?
Me dijo más o menos que iba a ser entre los 4.20 por ahí, más o menos, que el juez determinaba la última cantidad.
He had told me that it was going to be around the 420 area, but he would tell me in the next hearing.
All right, Mr. Sanchez, do you care to maybe elaborate a little bit on the child support for Mr. Vazquez?
Yes, Your Honor. The state calculated child support after speaking to Mr. Vazquez regarding income. He didn't have a monthly gross income of $17.33 with 33 cents, a net income of $1,457 with 32 cents. Calculated child support for two children at $64 per month with a step down of $291, and we calculated medical support at $78 per month. So yeah, he after you combine them, it's a little bit over 400. Yeah, so he is correct. Plus retroactive amounts. We also did calculate total retro of 511 of back pay, and recommending a payment plan 250 per month with step ups of 123 and then to 414. Those are starting February 1st.
Mr. Sanchez, can you provide the court with the that breakdown so that I can incorporate that as Exhibit A?
Yes, Your Honor, we can submit just an exhibit to the court that can be incorporated into the screen.
Okay, I'm going to place Ms. Malacara on mute because I know that we had some difficulty in, I guess, coming up with those numbers again, and I'm sure Ms. Martinez is having some difficulty because she's raising her hand. If you could just repeat those numbers again, please.
Child support of 364, and it will go down to 291 when there's only one child under 18, and medical support of 78 per month.
Okay, that's a grand total of how much that he's going to be paying monthly?
Combined, it's 442 per month plus the back pay, the $50 on the back pay.
All right.
There is $511 owed for back pay since their separation.
All right. Carlos, will you just translate the amount that he's being ordered to pay?
Yes. Señor Vázquez, se le estaba ordenando de la manutención de $442 mensuales, en adición de $50 de lo que estaba atrasado, de los $511.
Ok, 442 es lo que voy a pagar, ¿verdad?
En adición de los $50.
Ok. Que le va, más aparte de los 50 son, ¿qué? ¿500?
Plus the 50 is what, 500?
It's going to be 492.
492.
492, ok. Eso es un money orden solo, ¿verdad? No son separados de lo atrasado, del Medicaid y eso. Es todo junto, ¿verdad?
That's all together, right? Nothing.
Correct.
All right. Ms. Martinez, real quick. I know that you're giving me a reaction button. No? Oh, okay. I'm sorry. All right, go ahead, Carlos.
The 492?
Yes. Yeah, so it's all together.
Va a ser todo junto, sí. 492.
492 todo junto, ok. ¿Dónde voy a dejar el money orden o cómo le puedo hacer para pagar o en las oficinas del support?
Where do I go leave the money order or how can I do it? Where do I go pay at the office of child support?
We'll reach out to the party general for where to make the payments, and in the exhibit, we'll have our address as well.
And la oficina del Attorney General le va a llamar a usted, señor.
Okay.
Y luego también la orden va a tener la dirección y número de ellos.
Ok, está bueno. ¿Y a partir de cuándo te empiezo a pagar esto?
Okay, and perfect. And when can I start paying that?
February 1st is the recommendation to start.
El 1 de febrero es la recomendación.
Which is tomorrow.
Es mañana.
Ok, está bueno. Entonces ustedes me avisan para que me hablen para ir a dejar el cheque mañana. Entonces, el money order.
Okay, then y'all will tell me where so I can to know where to go drop off the check, I mean, the money order.
We'll reach out. I understand it's just one day, but we'll reach out. You'll be okay as long as it's within the month of February.
Sé que es un día, pero va a estar bien, con que sea durante el mes.
Ok, bueno, es lo que también iba a preguntar. Con que antes de que se venza el mes tengo que pagar esa cantidad, ¿verdad?
So before the month is over, that's when I gotta pay that amount, right?
Correct. It's recommended because it's already tomorrow, so yes. But after that, it's every the first of each month.
Es recomendado, sí, como mañana ya es el primero, pero ese va a ser el primero de cada mes.
Ok, bueno, y no tengo, por ejemplo, un ejemplo, ¿verdad? Que no tenga el día primero, pues sabes que me pagan hasta el día 7, 8, ¿me esperan días o tiene que ser el mero día primero?
And just an example, say I don't have the money on the 1st and I don't get paid till the 7th or the 8th, will you all wait for me?
You'll be okay. You'll be okay as long as you make the payments on his monthly basis.
Va a estar bien, señor, mientras que haga los pagos mensuales.
Ok, está bueno. Esto
Okay.
es lo que quería saber.
That's what I want to know. Thank you.
Okay, Mr. Sanchez, if you can submit that, I guess that settlement or this breakdown of the child support and medical support amounts, and then the PP2 language, I will incorporate that as Exhibit A into the final decree of divorce, and we will then, at that point, sign off on the decree, and they can get a certified copy. Ms. Malacara, as soon as Mr. Sanchez sends me that information, I will incorporate it as Exhibit A to the final decree that you have submitted to the court. We will sign off on it, and then you can get a certified copy through the through the district clerk's office.
Okay, when you guys tell me, I'll just go and pick it up, right?
I would say, give me about, what today's Monday, give me until about Wednesday.
Okay,
To get that done, okay?
Okay, thank you very much. Y'all
You're
have a
welcome.
good day.
You too. Mr. Vazquez, you're excused as well.
Señor Vazquez, ya se puede retirar usted también.
Ok, gracias.
Okay, thank you.
Mr. Sanchez, thank you for your help.
Thank you, Judge. See you.
All right. Okay, I know that Mr. Contreras probably has a quick default judgment, and then I can take up the last matters, which might take a little bit longer, but let me just make sure that Mr. Contreras is available. If he's available, can you turn on your microphone? Judge Contreras, are you available? Okay, how about Roger? Are you available then?
Judge, I'm here. Yes, sir.
We have not heard back from Mr. Gibson. So that being the case, we're going to go ahead and hear the case. I mean, Mr. Gibson has had almost an hour and a half to log on. This is CL 20-3358H, Andrea Corona versus Brianna Garza and Geico. Motion to compel defendant Geico County Mutual Insurance Company's motion to compel discovery responses. I'll hear from you, Mr. Garcia.
Yes, sir. Thank you. And Judge, just as a quick background, this is a personal injury motor vehicle accident that took place back on February 6th, 2020. If you recall, there was a third-party action that Ms. Corona filed against Brianna Garza, and that's where Michael Guerra comes in. Mr. Guerra is representing the third-party defendant, Ms. Garza, in this matter. And they went through the discovery process. I believe Mr. Guerra had an opportunity to depose the plaintiff, Ms. Corona. And then the petition was actually filed August 31st, 2020. Then that same petition was amended by Mr. Gibson on July 5th, 2021, wrangling Geico County Insurance into this matter. And that's what brought me into this case. We filed our answer August 11th, 2021. And initial disclosures mandated by civil procedure, rules of civil procedure were supposed to be filed by September 10th, and they were not filed. I sent Mr. Gibson a letter. I called him, reminded him of those disclosures. They were never produced. Then we filed our written discovery requests that were due by October 10th, 2021. And to this day, they have not been filed. And if you recall, Judge, we had a special exception on this matter where I argued that the underinsured coverage wasn't ripe because the third-party action was still pending. And we had a couple of hearings on the matter. Mr. Gibson decided to withdraw his attorney fees based on the Uniform Declaratory Judgment Act, and I agreed to it. But I also informed the court at that hearing that discovery had not been answered, and we were still under the 8 ball on this because of the late discovery. And unfortunately, there's a trial date scheduled for February 28th, 2022, with a status hearing scheduled with this honorable court on February 7th, 2022. And as the first party defendant, Judge, we're not ready to go forward. We still need to have those discovery responses produced. I still need to depose Ms. Corona and see where we're at. We haven't even been able to properly evaluate the matter. So simply asking the court for remedy on this issue, that demanding that Mr. Gibson file his or produce his responses so I have an opportunity to review and evaluate the matter.
So let me do this. Clearly, you will not be ready for the February trial setting. That February trial setting, our trial docket boards, I was just speaking with the other attorneys who have trial set for this afternoon, that we're going to be getting really, really packed with trials. Obviously, we are 2 years. This is 2 years in the making. We're backlogged 2 years, and it's going to be crazy. I use another word off in chambers, but let me just use the politically correct word and say it is going to be crazy here for the next 6 months to a year as it pertains to jury trials. So I want to put you guys back on track as quickly as possible. I agree you will not be ready. I don't want to penalize you guys. And so I'm going to put you guys back on the trial board. And I'm going to give you all a new DCC, remove you from the February date, give you a new DCC as quickly as possible. January 8th. January 8th. February. February the 8th. February the 8th at 2:30. February the 8th at 2:30 for a new DCC. And I'm going to order, I guess you're now requesting that Mr. Gibson comply. I'm going to at least give you the ability to, I'm going to order that he produce that discovery within the next 2 weeks, 14 days. Let me do 3 weeks. That way, if you want to come at him with sanctions, you can always do that. So 3 weeks.
That would be the 20th, Judge, February 20th, 2022?
Correct.
And thank you, Judge. So the court is now ordering Mr. Gibson to produce all his written discovery by February 20th. Just to summarize, we have a docket control conference telephonic call on February 8th, 2022 at 2:30 in the afternoon. Is that correct?
And all other settings are going to be removed. So you don't have to worry about status conferences or docket calls or any of that. That you're now on February the 8th, you're going to find out where you sit down the road.
Thank you, Judge. And as far as I believe this, Your Honor, you require mediation to take place before trial. Is that correct?
30 days prior to trial.
30 days before trial. And I'm not certain if the third party action has been mediated. I think Mr. Guerra can jump in on that.
No, Your Honor. As far as I'm concerned, we've only had the plaintiff's deposition. He chose not to take my client's deposition, and we haven't set up any mediation. I've tried numerous times, just like Mr. Garcia, to try and get a hold of Mr. Gibson, and it's either been no response or I'll get back to you, and I just haven't heard anything. So I know that I'm trying to see if I can get this case resolved, and I know Mr. Garcia is in the same boat, trying to see if he can get anything. So hopefully we'll hear something from Mr. Gibson soon, and I guess we'll just go from there.
February 8th, 2 o'clock, and DCC, all of the settings have been removed, and he's got till February 20th to respond for discovery.
Thank you, Judge. I'll submit an order before the end of the day reflecting what the court has just ordered. I thank you so much. Appreciate your time.
Your Honor, real quick, did you say just 2 o'clock or 2:30? I'm sorry.
Oh, I'm sorry, 2:30. I apologize.
Okay.
2:30.
No worries. I just wanted to make sure, Your Honor. Thank you.
Yeah. Thank you guys for your patience.
That's all I have before you on report, Judge. May I be excused?
You're excused. Thank you.
You're excused.
Thanks, Judge. You have a good day.
All right, you too.
Take care, Your Honor.
All right, and that puts us now with Mr. Contreras on the default.
Good afternoon. Oh, good morning, that is.
Yes.
Feels like afternoon already.
Are you ready to proceed?
Judge, my experts got COVID, Your Honor, so I'm seeking 10 days, at least CDC is 5 days, but I'm asking for a little bit more time because it should be better within 10 days, Your Honor.
Okay.
The expert is.
All right, how about the 16th of February? It's a little bit longer than that, it's 2 weeks.
What is it again, Judge? I'm sorry.
February 16th, is that okay?
Yes, Your Honor.
February 16th at 9:30.
9:30. Thank you so much.
You're
That'd
welcome.
be excused, Your Honor.
You're excused.
Thank you.
All right, that takes care of our docket for today. Court's gonna go ahead and